Mr. Kapil, just to break down and try to understand the nuances of what has happened, the very fact, the heart of this judgment, there are so many things. First being, the very jurisdiction of a government has been questioned. And a government has clearly been told that that's not your jurisdiction. It's not the Gujarat government's jurisdiction. It's the Maharashtra government's jurisdiction. Just to try and understand legally, is this usual? Is this usual for someone to overstep one's own jurisdiction in such a sensitive case?
Well, it's quite an interesting matter because this is quite a legal seesaw that has taken place. You see, before I answer this question, you will probably be surprised to know that the jurisdiction of Gujarat government came from an order of the Honorable Supreme Court. And therefore, what is being said as the jurisdiction having been usurped actually came in terms of a direction of the Honorable Supreme Court itself. Now it has been said that the said jurisdiction was usurped by non-disclosure of material facts by the accused who are in this matter, and that also the Gujarat government did not file a review petition, thereby supporting the accused. So when I said it is quite a seesaw, it is because of this, that you're absolutely right. This is one of cases where the jurisdiction of the court to deal with matters such as this has been decided. And the jurisdiction comes like this, that the matter was in Gujarat, it got transferred to Maharashtra. In Maharashtra, it went all the way to Mumbai High Court. The accused moved remission before the Gujarat High Court. Gujarat High Court rejected it. They went to the Honorable Supreme Court. The Honorable Supreme Court stated at that time that Gujarat government did have the jurisdiction to decide on the remission. Thereafter, the review that was filed was also by Bilkis Bano was also rejected. And thereafter, now in this present petition, now in January 2024, the Honorable Supreme Court has made 3 material observations. One is as far as the jurisdiction is concerned in cases such as this, saying to the court that took care of the trial is the court competent to decide on the remission and not where the, so to say, the case took place, etc. That is a material fact. The second important thing that was decided
Advocate, let me just interrupt you. Before you go on to the second point, Advocate Kapil, there's also another layer to this, and very closely with the jurisdiction is also this whole thing about a reformative theory of punishment vis-a-vis the women's right. And in this case, we were talking about a woman who was not only gang raped, but her family members were brutally killed before her. And this was, this was absolutely proved in court. The convicts are those in this case who have been convicted of this crime. And yet, you saw a debate here unfold about how either it be the government, Gujarat government, or the convicts in this particular case who try to hide evidence to fraudulently claim a particular kind of a verdict. How huge is this?
Well, this is very huge, but let me also talk about the law in this matter. See, what had happened was that there was a 1992 remission policy of the Gujarat government. They sought to take benefit of the remission policy of the 1992, which was only available for convicts or cases in Gujarat and not outside. So therefore, as I said, that though at the first instance, the Gujarat High Court had rejected it, but they went to the Honorable Supreme Court in 2022, the same was permitted and they came back and then took benefit of the 1992 remission policy. What was not disclosed was twofold. One, what was not disclosed is the 1992 policy already stand exhausted and that benefit could not have been taken by them. That's one. The second, what they did not or fraudulently disclose was that there were 2 contradictory stands in the Mumbai High Court as far as their case was concerned, and they sought benefit saying that since there is a contradiction and 2 different views, therefore under 32 the Honorable Supreme Court should look into it, in terms of which the Honorable Supreme Court had passed the 2022 order directing the Gujarat High Court to decide on that matter. So the Honorable